You know, when we think of a crime, we usually picture a bad act. Somebody does something wrong, and that makes them guilty. Seems pretty simple, right? Well, what if I told you that in the eyes of the law, what you do is often way less important than what you're thinking? Today, we're going to dive into the fascinating and absolutely crucial role of the guilty mind in criminal law.
So let's just get right to the heart of it with this question. Can you actually be found guilty of a crime you didn't even mean to commit? A crime where you had zero wrongful intent? The answer, believe it or not, is a surprising and, frankly, a pretty troubling yes. And understanding how that is even possible is what this whole explainer is about.
The key to this whole puzzle is hidden in what our laws say and, maybe more importantly, what they sometimes just don't say. This is what's known as the problem of legal silence. And trust me, it creates a massive gray area in our justice system. Okay, so here's the basic formula for pretty much any crime. For a conviction, you almost always need two things: the wrongful act itself and what lawyers call mens rea. That's just a fancy Latin term for a guilty mind. Simple enough. You did the thing and you meant to do it. But, and this is the problem, there are thousands of laws in the books that are totally silent on that second part. They describe the act, but they leave this big, giant question mark where the mental state is supposed to be.
So what happens when a law is silent on intent? Well, courts can interpret that silence as creating something called strict liability. And this is a serious legal trap where your state of mind becomes completely irrelevant. All that matters is that you did the act. Think about it like this. Imagine you're driving and your speedometer is broken, but you don't know it. You honestly believe you're going the speed limit, but you're actually speeding. Under a strict liability law, it doesn't matter that you didn't mean to. You did the act, so you're guilty. Period. It's a really dangerous path where honest mistakes can suddenly become crimes.
Now, legal experts actually saw this exact problem coming from a mile away, decades ago. Way back in 1962, a group of brilliant legal minds came up with a really simple, elegant plan to fix this issue and stop people from being convicted of crimes they never, ever intended to commit. This group, the American Law Institute, or ALI, created a document called the Model Penal Code. You can basically think of it as a master blueprint for what modern criminal law should look like. The whole goal was to make laws more consistent, more logical, and just fundamentally fairer all across the country. And it was a big deal. A lot of states used it to totally overhaul their own criminal codes. And at the absolute heart of this massive project was one simple but incredibly powerful idea. You shouldn't be found guilty of a crime if you don't have a guilty mind. The whole point of the code was to protect that fundamental principle, that intent matters. Their solution was so clever. It was basically a legal safety net, a kind of default setting tucked into a provision called Section 2.023. As legal scholar Scott England puts it here, this rule was designed to automatically read in a mental state, specifically recklessness, anytime a law was just silent on the issue.
And here's how that elegant default was supposed to work. It's really simple. So first, you've got a law that just forgets to mention intent. Second, instead of that silence creating that dangerous strict liability trap, the Model Penal Code's default rule automatically kicks in. And third, to get a conviction, the prosecution now has to prove you acted recklessly, which means you knew there was a big risk and you ignored it anyway. This one simple rule was meant to be the firewall protecting us from becoming accidental criminals.
It was a brilliant solution, right? A total legal game changer. You'd think that's the end of the story. But there was just one little problem. It didn't work. For the most part, that firewall failed, and that clever default setting was just completely ignored. So to figure out what went wrong, a really deep dive review by Scott England, published in the Oregon Law Review, looked at the criminal codes of these 25 states. These were the very states that were directly inspired by the Model Penal Code. And the goal was simple. Was this super important default rule actually being used the way it was designed?
Well, the results were just staggering. What the study found was that the overwhelming majority of these states had either messed up the rule when they adopted it, or they changed it so much that it became pretty much useless. That safety net that was so carefully designed, it had been dismantled before it ever really had a chance to work.
I mean, the scale of this failure is just so clear when you look at the numbers. Of the states that were supposed to be following the model, a whopping 88% completely deviated from the rule. Only a tiny fraction, just 12%, actually adopted the default setting the right way. The solution was right there on the table, but states just overwhelmingly chose not to use it.
So why does any of this matter? I mean, who cares about a nerdy legal provision from 1962? Well, we should all care, because its failure throws us right back into that original problem, the strict liability trap.
And this isn't just theory. It has very, very real consequences for people today.
Because without that default rule, the safety net is gone. And that leaves thousands of state laws wide open to being interpreted as strict liability offenses. What that means is that today, real people can be and are prosecuted and convicted for things they didn't even know were illegal or harmful. A small business owner could accidentally violate a super complex regulation. A driver could be held criminally liable for a totally unforeseeable accident. It just completely undermines that fundamental goal of a fair and just system based on whether you are actually at fault. But, the story doesn't just end with this big failure. Legal experts haven't given up. They're actually looking at how to fix the fix, how to rewrite this default rule so it works for the 21st century.
The whole goal now is to learn from the mistakes of the past. So the recommendations from scholars like Scott England call for a new, improved default rule. First, it needs to be way clearer, to avoid all the confusion that doomed the original. It has to establish a much stronger, more forceful presumption of recklessness, making that the obvious starting point for any silent law. And, crucially, it has to be designed to actually work in the real world, for the thousands of laws that are already on the books.
And it's so important to remember, this isn't just some dusty legal history we're talking about. The American Law Institute is still working on the Model Penal Code. It is a living, breathing document that's constantly evolving.
And I'm not just saying that. Look at this. Back in 2009, the ALI completely withdrew the code's section on capital punishment, basically saying there were just too many obstacles to making it fair. And then, literally just last year, in 2023, the ALI published a massive update to the code's sentencing rules. The work of reforming and refining our criminal law is happening right now.
And all of this brings us right back to that central question. And it kind of leaves us with this thought. In our incredibly complex world, full of rules and regulations, how do we strike the right balance? How much should our state of mind, our intent, our awareness, our guilty mind truly matter to the law? It's the question that sparked this whole debate back in 1962. And, as we've seen, it's one we're absolutely still grappling with today.